Good afternoon, everyone. My name is Kimberly Jarvis and I'm the convener of the Otago Women Lawyers Society, or OWLS as we are more commonly known. It's my pleasure to welcome you to the 20th Annual New Zealand Law Foundation Ethel Benjamin Commemorative Address. In particular, I would like to extend a warm welcome to our previous speaker, Justice Alan France, who has just this week been elevated to the Supreme Court bench, members of the Judiciary, Queen's Counsel, members of Parliament and councillors, members of the profession, the law faculty, the Law Commission, the New Zealand Law Foundation, the New Zealand Law Society, ladies and gentlemen. This address honours the life and career of Ethel Benjamin, the first woman to be admitted to the bar in New Zealand and the first woman in the British Empire to appear as counsel in court. For the past 20 years, OWLS, with the generous support of the New Zealand Law Foundation, has invited outstanding women of the law to deliver this address. The primary objectives of this address are to honour and preserve the pioneering spirit possessed by Ethel Benjamin, to encourage education and achievement in the women of today, to stimulate debate about issues affecting social justice and gender. While the specific issues facing Ethel may no longer hinder our modern day graduates of the law, issues of social justice and equality are still topical, and it is at forums like this that we have the opportunity to encourage discussion and shine light on those issues. This address has been presented by the highest calibre of speaker, and today is no exception to that. Our speaker today, like those of the past, is a woman who has a most impressive legal career and embodies a spirit of which Ethel Benjamin would be proud. It is with great pleasure that I introduce the Honourable Marcia Neave AO as this year's speaker. Ms Neave has had a career as a judge, a lawyer, an academic and a public policy maker. Throughout her career, she has always been passionate about how the law relates to women and responds to their needs. She has played an instrumental role in law reform in Victoria, leading inquiries and making recommendations to address systemic disadvantage faced by women and children, in particular victims of family violence and sex offences. Ms Neave was a legal academic for many years and has held chairs at 3 Australian universities. She has also been a research director and a part-time commissioner at the New South Wales Law Reform Commission, and in 1985 she chaired a board of inquiry into prostitution in Victoria, which recommended, among other things, the legalisation of prostitution under defined conditions. Most of her recommendations were adopted by government and became law in 1986. In the Queen's Birthday Honours of 1999, Ms Neave was made an Officer of the Order of Australia for her services to the law, and in 2001 she was awarded the Centenary Medal. In 2001, Ms Neave became the Foundation Chair of the Victorian Law Reform Commission, an independent statutory body which develops, reviews and recommends reform of Victorian state laws. During her time as Commissioner, she worked on law reform projects including defences to homicide, sexual offences and reproductive technology. Ms Neave was appointed to the Supreme Court of Victoria, Court of Appeal Division, in 2006 and was the first academic in Victoria's history to do so. The then Justice Neave stepped down from the bench in 2015 to chair Victoria's Royal Commission into Family Violence. The Royal Commission faced a huge task and a very tight time frame which led to it to complete its work. Together with the 2 part-time Deputy Commissioners and a dedicated team, Ms Neave was entrusted with the task of making recommendations regarding family violence support system and justice system in Victoria, including government and non-government organisations, police, courts, corrections and child protection. The Royal Commission received nearly 1,000 written submissions, consulted with nearly 850 people around Victoria, held 25 days of hearings with 220 witnesses, held expert roundtables and undertook extensive research. In just 13 months, they provided their final report to government on 29 March 2016. The Victorian Government has committed to implementing each and every one of the 227 recommendations. This is Ms Neave's first speaking engagement since the conclusion of the Royal Commission into Family Violence, and we are honoured to welcome her here today to present her engaging and topical address entitled The Victorian Royal Commission into Family Violence, Responding to an Entrenched Social Problem. It is with great pleasure that I hand over to the Honourable Marcia Neave AO to deliver her address.
I'm height challenged, so now I'm very high, but thank you, Kim, and also I want to thank the Otago Women's Law Society for your very warm welcome. My thanks also go to the New Zealand Law Foundation, the University of Otago Faculty of Law, and to the Williams Trust for having me here today. This is my first time in Dunedin. I've been to New Zealand many times, and I've been lucky enough over the last few days to experience some aspects of this very beautiful city. Your city boasts a university which has a proud history and reputation for educating women in all professions. The first woman graduate from the University of Otago graduated in 1885 with an arts degree, and the university was also the first in Australasia to permit women to take a law degree. Ethel Benjamin graduated in 1897 and was, of course, the first woman lawyer in New Zealand. I'm very proud to be giving this address today in Ms. Benjamin's honour. As Kim has touched upon, in March this year, the Royal Commission delivered our final report to the Victorian Government. This was the first Royal Commission of its kind in Australasia, and we made 227 recommendations, which we hope will transform the prevention of and response to family violence in Victoria and provide a model for many other jurisdictions. When the Royal Commission was announced in 2015, the Premier of Victoria identified family violence as a severe emergency and, I quote, the most unspeakable crime unfolding across Australia. Like New Zealand, Victoria has strong foundations in dealing with family violence, but the systems were overflowing under the weight of demand. Overflowing courts, high demand on police resources, increasing reports to child protection, and under-resourced services to help people affected by family violence. The Royal Commission was established in the wake of a number of terrible family violence-related deaths in Victoria. In 2005, Robert Farquharson killed his young sons by driving them into a dam where they drowned. In 2004, Luke Batty, an 11-year-old boy, was killed at a sporting ground by his father in front of his mother after Luke had finished cricket practice. Luke's death occurred despite a family court parenting order which gave his father some right to see him, a magistrates court intervention order, which is equivalent to a protection order in New Zealand, limiting the circumstances in which contact could occur, and attempts by Luke's mother, Rosie Batty, to seek help from the State Child Protection Authority to manage the risk posed by his father. I've only given you 2 examples of men killing their children, although there have been many others. Often these killings occurred in order to commit revenge on the children's mothers. Of course, women also kill children, but their motivations for doing so tend to be different from those of men. In Victoria, sadly, a woman is currently on trial for murder for killing her children by driving them into a lake. In Victoria, existing policy responses have been insufficient to reduce the prevalence and severity of violence. Continuing what we were already doing was simply not enough. The establishment of the Royal Commission was an acknowledgement of the seriousness of family violence and the terrible consequences it has for individuals, families, and the whole community. It also reflected, I think, growing community awareness that this is not a problem which affects a small number of dysfunctional families, but a problem which affects a very, very large number of people. Every year, significant numbers of women are killed by violent partners. The Australian Institute of Criminology's National Homicide Review shows that of the total 2,631 homicides which occurred in Australia over a recent 10-year period, 41% were domestic-related homicides. 75% of the victims who were killed by an intimate partner were women. Men also died in family-related homicides, but they are more likely to be killed by a parent, by their child, by a sibling, or by another family member than by an intimate heterosexual partner. In a substantial proportion of intimate partner homicides, there was a recorded history of prior violence and prior court orders. The population of New Zealand is, I think, about 4.5 million. The population of Victoria is around 6 million. But the figures in New Zealand are high as well. Of the 65 homicides reported in 2012, 42% involved a family relationship. Again, the majority of the victims of these family homicides were women. The death statistics are tragic, but they are only the tip of the iceberg. Many people are tormented by persistent and cruel physical, emotional, and financial abuse, often for many years. Again, adult women in heterosexual relationships are the majority of victims, but men, girls, and boys can also be affected. We also know that children who have either directly experienced family violence or been exposed to violence against a parent can go on to become victims or perpetrators of violence later in life. An Australian Bureau of Statistics survey, and this is a survey which has been conducted on 3 occasions starting in 1996, shows that about 1.5% of Australian women have suffered physical or sexual violence or emotional abuse by an intimate partner in the 12 months preceding the survey, and around 1 in 4 women had experienced violence by a male since they were 15 years old. The survey, of course, couldn't cover violence against children because of the ethical difficulties of surveying children and asking them questions of that kind. Children and young people are the invisible victims of family violence. In Victoria, police data shows that over a 3-year period, since 2009 to 2010, there has been a reported 76% increase in family violence incidents at which children were present. That's not an increase in incidents, it's incidents in where children were there. Exposure to family violence can result in children suffering from a variety of physical, emotional, and mental health effects, including depression, anxiety, low self-esteem, impaired cognitive functioning, and mood problems. One victim of family violence as a child told the Commission, and this is a quote, "I was incredibly suicidal from a very young age. It's very painful to think about. I remember being what could only have been about 6 years old and just crying and being so afraid, wondering how I could live if I ran away from home. I was also incredibly afraid of and obsessed by death. I was already starving and hurting myself when I was around 11. So I've sketched the enormity and prevalence of the problem in Australia, and I know that the situation is no different in New Zealand. I now want to move on to something that hopefully provides some directions for the future. An insight that I had when I was preparing this address was that family violence falls into the category of what policymakers sometimes describe as a wicked public policy problem. And that's not a term which I think is particularly familiar to lawyers. It's not about morality, as I'll explain. The term wicked in that context describes a problem which is particularly difficult to resolve. There are no quick fixes or obvious solutions. The Australian Public Service Commission recently summarised the characteristics of wicked problems in a policy paper. And I want to argue that the features of family violence which bring it into that category include the following. First, there is not agreement, there are diverse views about what causes family violence and how it can be prevented. It was put strongly to the Royal Commission that family violence is largely, though not entirely, attributable to gender inequality, and that the most effective strategy for reducing violence is to improve the situation of women, including in areas such as the workforce, public life. Other commentators argued that gender inequality doesn't necessarily explain violence by both men and women against children, by adult children against older parents, or violence against people with disabilities, or within same-sex relationships. It was also argued that improving gender equality wouldn't address other factors which contribute to family violence or affect individual abusers, including factors such as social disadvantage and unemployment, mental illness, economic inequality, and drug and alcohol abuse. Fortunately, our terms of reference did not require us to identify the causes of family violence. In my view, this would be an entirely fruitless task because complex social phenomena like family violence usually involve a very wide range of interacting factors. Our recommendations sought to address all of the matters that contribute to family violence, not just to violence by men against female partners. We addressed family violence in all its manifestations, as we were required to do by our terms of violence. We looked at all of the forms of violence that I've mentioned and looked particularly at violence against children, violence by adolescents and older children against parents, and violence involving other family members. So that's the first attribute of a wicked problem: lack of agreement about what causes it. Secondly, solving wicked problems usually requires cooperation and integration between different parts of government, between government agencies and non-government organisations, for example, health and welfare services, housing services providers, courts, police, and so on. And let me just give you a couple of examples of where that cooperation is required. Drug and alcohol services often focus on overcoming addiction, but don't focus on whether the client needs help as a victim or perpetrator of family violence, or the relationship between addiction and the violence. As another example, courts may make what we call a family violence intervention order excluding a perpetrator from a family home, but this will be ineffective, or may be ineffective, if the perpetrator has simply nowhere to go. He'll often be able to persuade his partner to let him back. Police failure to enforce breaches which occur when the perpetrator continues to harass the victim by constantly phoning or texting her or tracking her movements also means that the victim continues to be terrified and orders are ineffective. Failure to enforce breaches was a significant problem in Victoria. I don't know whether it is here. A third feature of wicked problems is lack of reliable data and inadequate evidence about the effectiveness of proposed solutions. This was a significant problem which we faced. So let me give you a couple of examples. There was no data on recidivism after a family violence intervention order, that is a protection order in New Zealand, was made. And evidence on recidivism, I would have thought, would be essential evidence in assessing whether orders are working. There was also a lack of evidence on the long-term effect of interventions, such as what are called in Victoria men's behaviour change programs, and whether they're actually effective to change conduct, to change the violence. That's in the context of intimate partner violence. The evidence on approaches which may work to reduce violence in other sorts of relationships is almost non-existent. The Royal Commission commissioned research to fill some of these gaps, but we know that solving a wicked problem like family violence requires ongoing data and evidence collection and constant looking at that evidence to see what's working and what is not. Fourthly, addressing wicked problems usually requires cultural, attitudinal and behavioural change. We know that family violence requires sustained effort at a community level to ensure that the problem is recognised and taken seriously, that it is prevented as much as possible, that victims are supported, and that there is early intervention when this can be done so that the problem doesn't get worse. Fifthly, wicked problems are usually entrenched problems. They've been with us for a very long time. And family violence, as many of the people here will know, is an example of that. Feminists first named violence by men against women in the 19th century, often saying it was caused by alcohol. By the late 19th century, men who assaulted their wives or partners were criminally liable in theory, but prosecutions were rare. Men who killed their wives were frequently able to rely on the partial excuse of provocation to reduce the crime from murder to manslaughter. I think that provocation has been abolished in Victoria, and I think it's been abolished in New Zealand as well. It's a sentencing factor only. It wasn't until the 1960s when feminists began to set up refuges and campaign for reforms that the law began to provide more effective remedies for women. Child protection authorities could remove a child who was being harmed by a parent, but this was often at the cost of removing them from mothers who were victims of violence themselves. So that notion that it's entrenched, that it's been around for a long time, is a serious aspect of family violence and many other wicked problems. Finally, wicked problems are often characterised by failure or limited success of previous reform attempts. And I think that that probably is a commentary of what has happened in this country. It's certainly a commentary on the situation in my state, Victoria, and in other parts of Australia. It would bore you all for me to talk about all of the steps that have been taken in Victoria over the years to try and address the issue, but I will just briefly mention some landmark legislation and practice changes. I do this because in proposing reform, you need to understand the foundations that you're building upon, what has worked and what has not. So we had legislation in 1987 and in 2008 to improve responses to family violence. And in the early 2000s, we also had some significant changes in public policy and practice, some of which I think apply here as well. One was a review of police practices, which interestingly came out of the appointment of the first woman Chief Commissioner of Police in Australia and in Victoria, and she set up that review, and that led to the adoption of a police code of practice to improve the police response. Another was to develop a common risk assessment framework, which was a mechanism for service providers to more accurately and consistently assess a victim's risk of harm. During the 2000s, a number of advisory bodies were set up to integrate services better and to get feedback from both service providers and victims of violence on what was working. There was also a specialist family violence division established in the Magistrates Court, and the Magistrates Court is the court which hears family violence intervention orders. So that division includes specialist magistrates and the appointment of court staff to support victims of violence and, in some cases, perpetrators. That model for the first time gave magistrates the power to require male perpetrators of violence to attend behaviour change programs. I think your judges have that power right across the board. And finally, recognising the high incidence of family violence in Indigenous communities by trying to encourage Indigenous leadership and support Indigenous communities to prevent family violence and support victims. These were really positive developments, but as is often the case with wicked problems, their effect was limited. So I'm now going to just say a few things about what led to the establishment of the Royal Commission, in addition to those terrible cases that I've described early. This was a recognition of the problems in the system. So in Victoria now, and I think in every state in Australia, family violence intervention orders are largely initiated by the police. They apply for the order. Around 2/3 in Victoria are sought by the police on behalf of the victim. But despite that, many victims continued to be ashamed or too frightened to report violence. Despite the introduction of the Police Code of Practice, some training for new police recruits, and the creation of specialist family violence teams in the police, some police remained ignorant of and resistant to the problems experienced by victims of violence and didn't regard this as real policing. Real policing is, chasing armed robbers and dealing with murders and so on. One of the difficulties was that victims in different parts of the state experienced different levels of police response, some excellent, some very bad. And there was no mechanism in place to audit police performance. Indigenous women were particularly critical of police responses. As well, and I mentioned the specialisation in the magistrates' courts, but not all family violence cases go to the specialist courts. Many applications are still heard by non-specialist magistrates and court staff in crowded courts, lacking proper facilities to support victims and keep them safe. In New Zealand, I think you've done much better than we have in the context of legal aid. We have duty lawyers to support victims of family violence, but because of the number of cases they're doing, they often can't provide an appropriate level of service. You get your 2-minute consultation, and that may be sufficient. That may be all you get. Not all victims could get access to the other services they needed, including housing and support with further education and training, so that they can become economically independent if they're not already able to support themselves. Victims in rural and regional areas were often told to get on the train and come to Melbourne, because it was only in Melbourne that accommodation would be made available for them. These failings were heightened by increasing numbers, which placed pressure on courts, police, service providers. Between 2009-10 and 2013-14, the number of incidents recorded by the police increased by almost 83%. Now, this is not necessarily an increase in the phenomenon, it's an increase in police involvement. So, in some ways, you could say that it's showing that the system is working better, but it places enormous strains on the system. Number of applications in the Magistrates' Court increased by 34.5% over the same period, and nearly 40% of people seeking assistance for homelessness were affected by family violence, and this demand could not be met. Because of that need to focus on people who needed help immediately, there was very little room to think about prevention or early intervention to prevent family violence escalating, or on helping women and children and others affected by violence to recover from its effects once an immediate crisis had been resolved. Victoria's response to family violence had become an ambulance at the bottom of the cliff scenario. So one of the strong themes in our report is that need to think about prevention, early intervention, but also about supporting people once the immediate crisis is over. I won't have time to talk about all that, but it's a very important theme in the report. So we addressed the features which make family violence a wicked problem in three main ways. First, the questions are policy-based. We were a policy-based Royal Commission, and so we used well-established law reform processes. We used a non-adversarial approach, in a way attempting to model a different way of dealing with social problems. Counsel for the state was present at the hearings, but did not call witnesses or cross-examine. Listening to the voice of people affected by family violence was integral to our work. Their experiences helped us to identify the themes which we pursued in our formal hearings and arrive at our final recommendations. We consulted people in a safe way, that is, we were concerned about their physical safety, but we also ensured that psychological support was available to anyone who gave evidence in our formal hearings or who participated in our consultations. We also held a number of expert roundtables which helped us to refine issues and test our tentative thinking. So we put some propositions to experts in particular areas. We found also that by calling experts to give concurrent evidence in a panel in areas where there was controversy, this was a really good way of exploring differences of opinion. I assume that in New Zealand you do what we call in Australia hot tubbing, where we call expert evidence in usually civil matters. Well, we used a similar sort of process in our Royal Commission hearings. One area, for example, was men's behaviour change programs, where there are very diverse views about whether they work or not. And so we called a group of people and we allowed them to debate the issue in a formal public hearing. International experts were called to give evidence online, and we were lucky enough to have some very helpful witnesses from New Zealand. A second feature of our process involved what I'll call learning from history. That is, looking at what's worked in the past in Victoria but also in other places and trying to assess why particular strategies have worked or why they've failed. We considered the various pathways through which victims and perpetrators come in contact with particular systems and how institutions and systems respond, and that enabled us to identify some opportunities for earlier intervention. And thirdly, and I'll say a little bit more about this in a minute, we proposed government and non-government structures to support implementation and to lead the reforms. We knew that law reform and policy change that stands alone without leadership, implementation strategies, and a whole of government approach would not bring about change. So I want to finish by making some very tentative comments about what New Zealand might learn from some of our recommendations. And of course, you're the experts on New Zealand, I'm not, but these are some of the things that we learned. There is no silver bullet to bring about change to prevent and respond to family violence. But we asked that our government integrated our recommendations into a 10-year plan to bring about change. You'll note if you ever look at our report that we had timelines affixed to every recommendation. Some were things that had to be done within a year, some were things that had to be done in 2 years, some were things that had to be done over a longer period. And that was all meant to be pulled together to produce a 10-year plan. So, first, a new governance structure to oversee the whole thing. The Commission emphasised the importance of bipartisan leadership to ensure that family violence remains on the government policy agendas, regardless of the party which is in power. And you all know this, a lack of a bipartisan approach often produces policy discontinuity. The laudable desire of a new government to make its mark on an area of community concern can sometimes result in defunding, abandonment and dilution of earlier initiatives, even when they're working. Our recommendations included the establishment of a bipartisan parliamentary committee on family violence. That's an approach which in Victoria has been very effective in the area of road safety, so we're sort of using that as a model. I've mentioned community leadership already, but we emphasise that community leadership and the involvement of workplaces, sporting organisations, faith communities and other civil society institutions is vital to create cultural and consequent practice change. When I use the word culture, I mean both the culture of particular professional groups, police, lawyers, judicial officers, which influence the way they go about their work, but I also mean community values. Work in that area was underway before the Royal Commission was established, but we made recommendations to support and expand those activities. We recommended family violence training for all key workforces, including hospitals and schools, and recommended that there be a mandatory respectful relationships education for children and young people at all year levels to challenge negative attitudes to women and to change broader social attitudes to the use of violence. And just by way of an anecdote, some of these programs were running. We recommended that they be beefed up and expanded. And one of the interesting things that a headmaster told us was, well, the children have been doing this and some of the parents have been coming to us and saying, could we sit in because we'd like to learn what our children are learning. So that was a grassroots program directed at children, which parents in a very poor country town with a high level of family violence, some of those parents were interested in participating. We also considered that a wicked problem like family violence won't be resolved unless there's coordinated whole of government approach. Departmental lack of cooperation can undermine policy initiatives and make it difficult and sometimes impossible for people affected by family violence to receive the services they need. There had been attempts made to integrate public service provision better in the 2000s, but over time they lost impetus and those programs have dwindled. So we recommended a new system architecture which included having a cabinet subcommittee on family violence chaired by the Premier, which would have responsibility for approving the 10-year family violence plan, and arrangements for supporting regional structures to deal with issues of prevention and support. We also recommended new governance structures in the senior bureaucracy, heads of government departments, to promote a whole of government approach and improve liaison between the agencies which fund services. We also recommend structures to ensure that feedback from victims of family violence about how the system is working got through to the policymakers. Many victims of family violence told us about inadequate service integration with systems such as housing, health, specialist family violence services operating in separate silos. One woman subjected to very serious violence who gave evidence lived in a car for a year with her 4 children because there was no suitable accommodation for a family of that size. She was told she could split the family and she could take 2 of her children live in housing, but the other 2, what would happen? We were very helped in thinking about this issue by the New Zealand Productivity Commission review of social services, which talked about this problem of system integration and what you do about it. One of our important recommendations was to establish 17 support and safety hubs in regional areas throughout the state. And the idea of these hubs is that they would receive referrals from police, service providers, family, friends, health authorities and so on, to give immediate direct assistance to victims until they could be given longer term support. So these hubs are a single entry point for a person to find help quickly and get immediate housing, psychological support, whatever might be needed. Not for the long term, but until better services can be rolled in. That support and safety hub recommendation was also intended to bring together information about victims and perpetrators so that risk assessment could be made more accurately. Next, the importance of data, and I've gone on about this already, but we made recommendations to ensure that future family violence policies are based on evidence rather than on assertion or ideology. And I've mentioned the lack of data in Victoria. New things that people tried often lacked feeding and monitoring mechanisms so that success was not recognised and new approaches could not be fine-tuned. We recommended an independent statutory family violence agency to liaise with relevant groups to commission research on the operation of family violence, and so that they could oversee the performance of the whole system, not just little bits of it. The agency will also encourage sharing of information about approaches which are showing promise. Another theme in our report was focusing on perpetrators. In the past, the focus has been on victims entirely. Designing an effective family violence system requires much more focus on perpetrators. It should not rely on victims to manage their own safety. I've mentioned that there's insufficient follow-up of the behaviour change programs that we have in Victoria. It's not possible to monitor completion rates, oversee the quality of the programs, and we don't know if the programs are effective in preventing long-term recidivism. All those matters need to be at the centre of a family violence system. Protecting victims also requires the collection and sharing of information about perpetrators. We recommended the establishment of a secure central information point led by Victorian Police, and this will give staff from police, welfare services, justice and so on the ability to obtain information from their separate databases. And then that information is brought together and considered by a panel which can then feed back its recommendations about risk management to the support and safety hubs. We also made recommendations to remove some of the legislative barriers to information sharing, some of which are more perceived than real. People are frightened sometimes to share information because they think they might be breaching their work obligations. But that information sharing aspect needs to be much better shared. And victims need sometimes to have access to that information. So victims should be informed when a perpetrator is released from prison or when somebody that they've been in a violent relationship with moves back into their area. Next, protecting children. The final report emphasises the importance of investing in the future by protecting children from violence and helping them recover from its longer term effects. A child who lives with violence, though forever changed, should not be forever damaged. There's a lot that we can do to improve children's futures and break cycles which may otherwise be repeated. Among our child-focused recommendations, we proposed much better information exchange between police, family violence services and child protection, greater training for child protection practitioners about the nature and dynamics of family violence, and better training for family violence services about the effects of violence on children. Historically, they've operated in separate spheres. They've had different paradigms. You've got the child protection authorities worrying about the children and not thinking awfully much about what violence may be doing to their mother or father. And we've had the family violence services focusing on the adults the adult victim rather than on the children. And so we proposed a number of mechanisms to bring that information together. I might say that the need for that was also identified in the coroner's inquest on the death of Luke Batty, the little boy who was killed by his father. We've recommended funding of therapeutic interventions and counselling for children and funding of youth homelessness services. And finally, in that area, we've also recommended mechanisms for early intervention to provide an effective response to children and young people who are themselves using violence and who may go on to do so as adults. Finally, you'll be relieved here, I want to mention our recommendation that transparent funding mechanisms be put in place to determine how much the government spends on family violence policy responses. We can't work out what investments in this area will save unless we know what is being spent. New Zealand government is much further ahead than our government was in this area. In 2014, it assessed expenditure on family violence, sexual violence and child abuse services, which then amounted to $1.4 billion per year. But only a small part of that amount went to primary prevention. That was nearly all on provision of hospital services and those sorts of services to victims. We recommended a significant increase in the funding of relevant services, including an immediate housing blitz and funding of a support package to assist victims of family violence to obtain housing, improve their work skills and to get psychological support. So the idea is that people will have a 2-year package and they can, with the assistance of a support person, work out where they need money to be spent, if they need it, for example, to subsidise housing for them while they get on their feet. I'm glad to report that in its recent budget, the Victorian government announced additional funding of about $500 million. It's a lot of money, $500 million, to implement the Commission's recommendations. More money is a very important part, but not the whole of the solution to the wicked problem of family violence. The Royal Commission exposed its pervasive nature and its dreadful effects. As is often the case with good public policy reform, the identification of problems in the system through our submissions, which were put on website, and our public hearings, which were live streamed, and our consultations, encouraged all those involved in this area to think about and begin working on change before we finally report it. I understand that New Zealand is facing an increasing level of family violence. There is a real opportunity to transform the way that we respond to and address this social evil. That requires us all to be involved. I'm delighted that there are a number of men in the room today because you are people who can talk to your colleagues about behaviour which reinforces and supports attitudes which contribute to violence. As we said in our final report, and I quote, broadening responsibility for addressing family violence will require each sector or component part of the system to reinforce the work of others, to collaborate with and trust others, to understand the experience of family violence in all its forms, to look outwardly and to be open to new ideas and new solutions. Thank you very much for listening, and I hope this address encourages discussion and reflection about how we might all contribute to this problem.
Hello, I'm Ruth Ballantyne and I'm the Deputy Convener of the Otago Women's Lawyers Society. On behalf of OWLS, it is my absolute pleasure to thank our wonderful guest speaker, the Honourable Marcia Neave AO, for your excellent and extremely topical address today. You and your team at the Royal Commission into Domestic Violence are to be commended for your incredibly hard work in producing such an impressive and comprehensive report. Indeed, it is so comprehensive that it is spread across 8 volumes. and contains, as we've heard, 227 individual recommendations to reduce and ultimately prevent all forms of family violence. There are 4 things that I particularly like about the report, which you have touched on today. Firstly, and most importantly, the extensive consultation process with those affected by family violence and those who work in this area is particularly commendable. Too often the voices of those who live such violence and those working at the front line are just not heard. I also like the fact that you have focused on practical, real-life solutions to actively reduce family violence in all of its forms, rather than just determining the causes of family violence and condemning it in an abstract way. Best of all of your recommendations come with timeframes and other accountability measures that must be met, which I think is a fantastic step forward. Thirdly, I really appreciate that you examined family violence in all of its forms, including violence against children, parents, violence against older people, and those with disabilities. The list goes on. Such a broad approach is very important. Lastly, the development of a 10-year bipartisan plan to effect change, regardless of what political party is in power, is truly inspiring, and I really would like that here. I would also just like to point out that this report was delivered on time and significantly under budget, which is a huge achievement in itself, and one you should be commended for, Ms. Neave. As you rightly point out, New Zealand also has disproportionately high levels of family violence, and there is a lot we could all learn from your report. I hope that one day we too can implement some of your recommendations to make New Zealand a safer and fairer place for those most vulnerable in our society. We will follow Victoria's progress with much interest. We really appreciate you giving up your time and travelling here to share your wisdom with us today. Please join me once more in thanking the Honourable Marcia Neave AO. I would now also like to take the opportunity to thank our incredible sponsors, the New Zealand Law Foundation, the University of Otago Faculty of Law, and the Williams Trust for their continued and very generous support. Without your support, today would not be possible. Thank you very much. I would also like to thank the people who helped organise today's event, especially my fellow owls on the committee and our very able convener, Kim Jarvis, as well as the Dunedin Public Art Gallery, Inspired Pantry Catering, which is out there, and the University of Otago AV team. Owls are also very grateful to all of you for attending today's address and for your continued support of our organisation. I would now like to invite Christina Muller to say a few words on behalf of the New Zealand Law Foundation.
Thank you, Ruth. The Otago Women Lawyers Society has again chosen a very distinguished speaker to speak on a subject that is topical and important. On behalf of the New Zealand Law Foundation, I would like to add my thanks to Ms. Neave for her interesting and thought-provoking address. As Kim mentioned, the Foundation has supported the Ethel Benjamin Address since its inception 20 years ago. We are all here because we support the cause of furthering the advancement of women and other disadvantaged groups in society. I think that annual events like this are important because they give us an opportunity to pause, to take stock, to take heart or otherwise from what has been achieved, and to think about what we personally are doing and could do to further a cause very dear to our hearts. The New Zealand Law Foundation also honours Ethel Benjamin through its own annual event, the Ethel Benjamin Scholarship. This is open to women in the early years after graduation to undertake postgraduate studies. This year there are 2 Ethel Benjamin Scholarship winners. They are Holly Hedley, who is a graduate of Otago University, and Bree Huntley, who graduated from a university in a very large city at the other end of the country. I was on the selection panel for the final interviewees, and they are both very accomplished women who have very promising futures. While I'm here, I'd like to pay tribute to Donna Buckingham, who has done a fabulous job in helping us run the Ethel Benjamin program. She not only sits on the final interview panel, but has contributed to the much more difficult and time-consuming process of assessing a large group of outstanding women and deriving a small group to go through to final interview. It is heartening that Dunedin has such an active and engaged legal community. The New Zealand Law Foundation has a close relationship with the Otago Law School and the legal profession in Dunedin, funding many worthwhile projects here. Current key Otago projects are an evaluation of the recent reform of family law proceedings, a study in the progression of civil litigation, work on appeals in the accident compensation scheme, research on selective reproduction and the genetic testing of embryos, Dr. Jacinta Ruru and Justice Joe Williams study Te Akinga, a Brooker's Maori law treatise, the new Conflicts of Law Research and Database, and the Donald Beasley Institute's work on best evidence, best practice. In addition, we are providing funding for several symposia, one on law and medicine, a roundtable on private law, the law of obligations, a colloquium on relationship property, and 2 forthcoming Festschriften for Professors Skegg and Smillie. And I do hope that you'll participate in those if you can. Finally, there's the National Family Law Moot at the end of the month, and Professor Graham Virgo's Distinguished Visiting Fellowship visit, which the University of Otago is hosting. All in all, the Foundation has funded just under $6.5 million to Otago University over the last 20 years. I would like to acknowledge the Foundation's 2014 International Research Fellow, Alison Douglas, who is here in the audience. Her work went to the publishers, I think, last week. And also her immediate predecessor as International Research Fellow, Kerry Warnock, whose project is to analyse the work of the New Zealand Environment Court in its first 36 years. Finally, I would like to compliment OWLS on the excellent work it does in organising this annual event, which the Foundation is delighted to support, and invite you to join me in thanking our speaker, Ms. Neave, although I might be preempting Ruth. Okay. Please join me.
Thank you, Christina. Once again, a huge thank you to the New Zealand Law Foundation for your support, and to our wonderful speaker, the Honourable Marcia Neave AO. I didn't even have a clap in there. That brings the 20th Annual New Zealand Law Foundation commemorative address to a close. Please join us for light refreshments just outside in the ODT gallery, and thank you very much.